Good evening, class. Online class, is the AV working? Online class, is the AV working? Yes, no, something, online class. Okay, good. So today we'll be discussing about polity and governance ka current affairs. These are the topics of today's discussion. Child Nutrition Report of 2025, timelines for governors, and also we'll be discussing e-sign feature which was launched by your election commission, Pragati and personality rights. Okay. First topic, Child Nutrition Report of 2025. Okay, let's start. See, recently your UNICEF had published a report. The name of the report is Feeding Profit. Okay, how food and environments are failing the children. UNICEF, when it released the report, look at the word it's showing, feeding profit. First and foremost, it gave out a study wherein it said, let's take in South Asia itself. South Asia means your countries such as India, Afghanistan, Pakistan, Nepal, Bangladesh, Myanmar, Sri Lanka, Nepal, Bhutan, all these countries. Among all the South Asian countries, 8 South Asian countries. Now, the school children will go, right? They'll eat food, not the ones that they pick from home and go, but something that is easily accessible to them, be it school canteens or school lunches. The foods that were served for them were extremely unhealthy. I'm not just using the word unhealthy, I'm using the word extremely unhealthy because all of those were laced with sugar and the sort of food which we call as ultra processed. Ultra processed, high in calories, high in sugar, high in fat, high in sodium. So much so that the foods which were conventionally once used, such as your fruits and vegetables, have been completely replaced by your ultra processed foods and high in sugar, starch, that is high in sugar, calories, sodium and fat kind of foods. So whatever we are feeding the children, it is only where the profit of your industries, that is anyone who makes the foods, ultra processed foods, their profit is what is being fed to the children. It is not nutrition or food. Understanding? Because of this, the children are facing higher risk of overweight, obesity, so much so that, see, we have this thing called as overweight. At least you know by the term, that is, your height to weight ratio, your weight is more. Otherwise, what we call as BMI, body mass index. We also have the scenario in the world where we call it as underweight or undernutrition. One is overnutrition, another is undernutrition. For the first time in the history, the overweight had more percentage than the underweight children. See, whenever I use the term overnutrition, do not confuse it for they're getting too much good nutrition, too much of good nutrition. It means, again, it is too bad. It is not nutrition, but it is just sugar, salt, fat that is put into their body. Understanding? That is also bad. Anything in the over or under is a bad category, only the normal thing is good. But we are moving closer and closer towards the overweight scenario. Understanding? That is what your UNICEF report stated, that childhood obesity and unhealthy foods are increasing throughout the world, not just in India, throughout the world. Shall we move ahead? You want to write something? If you see the report ka findings, it said that 1 in 5 children, okay, here they have called adolescents, means 5 to 19 years of age, are overweight. Out of 5 children, at least one child is overweight. Let's just pause for a minute. Okay, let's continue. So 1 among 5 children are overweight. And if you see, the obesity has overtaken underweight for the first time, which means more people are obese than underweight. Okay, usually underweight was associated with as a third world situation. Only in poorer countries, African countries, South Asian countries, there used to be underweight, it was seen. But if you see, the obesity is also becoming higher. This is for children aged less than 5 years. Let's say the adolescents, according to WHO targets, all this is. Overweight means your body mass index is greater than 1 standard deviation. Obesity means BMI is greater than 2 standard deviation. This is less than 5 years, this is 5 to 19 years. WHO considers 5 to 19 years as adolescence. Okay, less than 5, weight to height greater than 2 standard deviations. Obesity, otherwise called as severe overweight, is greater than 3 standard deviations. With respect to adolescence, it is different. Overweight is 1 standard deviation, obesity is 2 standard deviation. Done? Shall we move ahead? So if you see in India, how is the overweight problem? It has become increased, meaning according to National Family Health Survey number 3 to National Health Family Survey 5, 127% of increase is there in under 5 obesity, that is children from 0 to 5 years is having 127% of overweight issues. Why children? Now we can tell, if you are going to start eating junk, it will be possibly after 5 only. How will 1 to 5-year-old child eat junk? This is where we say for a lot of reason where a mother cannot breastfeed, this markets have created something called as formula milk or alternate milks, telling that these will provide the equal nutrition of how a mother's milk is. But that is the reason why under 5 obesity has increased to a whooping 127%, because the main ingredient in this formula milks were your sugar. Understanding? So, adolescent girls obesity increased by 125%, for boys it increased by 288%. If this keeps on going, the same trends keeps on going without any difference, then obese children by 2030 in India alone, okay, and when we say India alone will rise to a higher limit, but if you see to the global level, it will be even more higher, that is to previous compared trend, global trends will rise by 11%. Write this as to why under 5 obesity is coming. Under 5 obesity is this, whereas your adolescent girls and boys, coupled with the sugary drinks, ultra processed drinks, fast foods, high in calories, high in sugar, high in sodium, there is also lack of physical activity. Coupled with high screen time starting as soon as your age 1 itself. Done with all this? You have heard of this thing, millennials, Gen Zs and all those things? 2025 ka children, that is in the year 2025, so who and all are born, and this is a continuing year, right? This generation is called as Gen Beta generation, which means they are born with artificial intelligence. Not the children are born with artificial intelligence. The era of them is coupled with artificial intelligence. So they don't know a world without artificial intelligence. So this is getting more affected because of your screen time, because of your physical inactivity and also sedentary lifestyle. Write this down. Done? We'll move ahead. What are the implications if we leave on this obesity, overweight to go on? diabetes, hypertensions, and also a different type of cancers alongside your gastronomical issues. One reason why I'm telling gastronomical issues is because our gut is supposed to have a complex microbiome that is entirely ruined because of your ultra processed foods. And the obesity cost in India alone is costing 1% of our GDP, that is 27 billion in 2019. Now it is said that by 2060 it will cost 2.5% of GDP. The amount we are spending on education is how much the costing of obesity will lead to in 2060. This is the report by your UNICEF. This number write down. Done? Once India was known for having diseases which are coming through communicable diseases or with respect to genetic diseases. Today, more than half of the diseases are because of unhealthy diets, environment, lifestyle, sedentary activities. We'll move ahead. So, what are the India's initiatives to curb with obesity? Fit India movement. Okay, just write down Indian initiatives and write this down. Fit India movement, Eat Right campaign, Poshan 2.0, Online class now this day we working?
Yes, ma'am.
Okay. Next topic is, can timelines be fixed for governors? First and foremost, the context is because the president has asked Supreme Court's opinion on one question. What is that question? Can judiciary fix timeline for governor and presidential assent? Otherwise, they have asked on the question of Article 200 and 201. Okay? We'll move ahead. The trigger point for your President of India to ask this question to judiciary is behind this particular case. State of Tamil Nadu versus Governor of Tamil Nadu case, in which judiciary gave a timeline. Understanding? It said that, see, governor, when he gets a bill, technically he has few options. First is, he gives assent to the bill. Assent means he signs the bill. Second is withhold the bill. Withhold means reject that bill. Okay. Then third is, he will return it for reconsideration, but once it is passed back, he has to mandatorily sign it. Next option is, the governor can reserve the bill for the president. Okay. Last, in polity you would have also heard of pocket veto. Right? Which means take the bill and take no action on this. Judiciary has now crossed out this, telling that you cannot remain taking no action on a bill. You have to do one of these. Meaning, within 3 months time we are giving you to act on the bill. Give sign to that, or reject that bill, or reserve that bill. Now when the president gets this bill, he has 3 months to decide what he should do. So 3 months for governor, 3 months for president. If this delay, if a governor or president delays a bill beyond this, then judicial review will be applicable. How it was applicable in state of Tamil Nadu versus governor of Tamil Nadu case. This is the issue. Now what happened? Immediately the center came out and told that, how can judiciary interfere into a matter that is present in the constitution? Constitutional has given a provision for governor as constitutional discretion. That is, he is supposed to do what he is supposed to do. That is why the word discretion. How are you coming and dictating how a governor should be? Why are you unnecessarily entering into the issues of center and state? First thing. Second thing, the union, that is the center, has also held that if any conflict is there between center and state, they should decide among themselves. We don't want judiciary to overstep its boundaries. Now, how the states are reacting? States means opposition ruled states. Let's say now in the center there is BJP ruled government. In states which are non-BJP ruled government, those states are pointing out that purposefully the governors are being partial to us. Governors are appointed by the center only, right? They are being partial to us. Unnecessarily they are delaying our bills. They are undermining the popular, let's say the popular support, means people ka support se they have come to power. So if they are passing the bill, it is because of people's will. Now this governor is delaying our bill. Okay, this is what the states have voiced out the complaint. Now for which we will see Article 200, which tells he has 3 options: sign the bill, reject the bill, return for reconsideration, or reserve for the president. One issue in the constitution is, it has told the governor must act as soon as possible, which means no time limit is mentioned in constitution. Okay, this the central government is telling as governor's discretion. This judiciary is telling us, no, you do not have any such discretion. This point is the issue of Article 200. Okay, we'll move ahead. Then if you see the same with respect to governor's power is Article 201. Again here also no time has been given for, that is no prescribed time either for him to sign or reject also. If he is given a bill, let's say, even to not take an action or to sign, he has not been given a time limit. Article 163 by 1 is again brought in. Governor is bound by Council of Ministers aid advice except where discretion is explicit. The question again comes here. What is the governor's discretion? This is not defined clearly. This is again where center is telling this is governor's discretion, you cannot intervene. Judiciary, when it has now the president has asked the question for judiciary, judiciary will take some time to give its advice. But as of now, when your Tamil Nadu High Court and all was involving into this, it gave a decision based on online class. Is it audible? Okay. It gave a decision based on previous decisions. First thing is Shamsher Singh case of 1974. Judiciary held that governor is a constitutional head and he must act according to the aid and advice of ministers. Okay, one example you will understand. 2025, that is in your Tamil Nadu case only, governor shall concept is mandatory, not discretionary, which means governor shall take action on the bill mandatorily within 3 months limit, judiciary told. Judiciary told this is because of taking into a previous exercise or previous court decision of Nabam Rebia. This issue happens in Arunachal Pradesh, where generally to call a session, let's say a state legislative assembly, the CM and COM should tell the governor, call the house. At this point of time, neither the CM nor COM had told the governor to, okay, this is the name of the governor to call for the house. He himself called on his own. This is when judiciary told that you as a governor have no right to call for a house session on your own, but you have to act according to the aid and advice of COM. Navam Remia case took the help of Shamsher Singh case. Your 2025 case, that is your present Tamil Nadu case, took help of both these cases and told that you have a fixed 3-month limit to take an action on the bill. Okay? Understood? This
same thing applicable to the president also?
No, only governor, no, not president. Now, if you see the previous commissions, they will recommend how and all changes should be brought in the constitution. Sarkaria Commission and Panchi Commission both asked for reducing the discretionary powers of governor, and they also had told we have to set a limit, but they had told a limit of 6 months. Again, Sarkaria Commission, Panchi Commission, all the advice are just merely recommendatory in nature, it is not binding. Sarkaria Commission told reservation of precedent, that is bill to precedent, should happen only in rare case, and that also should be decided within 6 months. Panchi Commission also told that the bills must be decided within 6 months, but present day judiciary made it for 3 months. Okay, this is the next topic. Election Commission launches e-sign feature for voter roll management. Online class, again voice is not audible. Online class, is it audible now? Let me get it corrected. Online class, is it audible now?
No, ma'am, it is not clear.
I'll get it rectified. Okay. So the next topic is Election Commission launches e-sign feature. Now look at this. First and foremost, your Election Commission has come up with a new feature. That is your e-sign feature. Where is it added? Your Election Commission has a portal, online portal called as ECI Net. Okay, Election Commission of India Networks, wherein if you are any new voter, okay, then you have to register using form 6. If you are an existing voter and you see your details are all mismatched and if you want to delete it, then you will use form 7. For any data that is more of, let's say, only few, your name ka initial, something is changed, you can go for correction. For that you will use form 8. What happened is, this was there from before itself. Now, in two constituencies, I'll show one. Let's take example of Karnataka. In one of the constituency, they found huge discrepancy. More than 5,000 odd names were left out. Okay, because of that, they introduced one feature. Let's say anyone who has to use these forms, they have to e-sign, that is electronically sign, understanding. So their data will be now more secured. Immediately they can't go and sign. First they have to log in, they have to use their Aadhaar credentials, and then they will be given an OTP based on that Aadhaar number. Then they will be sent to this link page and here they have to sign. So when a person is identifying his details and then he is verifying it, the possibility of error rate reduces. So this is Election Commission moving more and more towards digitization. Now what happened was, in Karnataka Aland constituency, more than 5,994 deletions have happened, and in Maharashtra ka Rajuri constituency, a lot of false additions have taken place. To curb this, they introduced this e-sign feature, understanding, which means a person has to verify his data, tell all it is correct. How? Using his Aadhaar card mobile number, he will log in, then he will link his data. Then once he gets all his information, if he or she feels correct, then they will sign digitally. Understanding? Earlier, the phone number was linked to your EPIC card, voter ID card, without Aadhaar verification. But now it is linked with Aadhaar verification. Why it was not linked to Aadhaar verification earlier means, all your biometric data will now be linked with your voter ID. That was the fear. Now they said no, in order to curb this amount of manipulation, we will link it with Aadhaar. Okay, this is done by a CDAC. CDAC means anything with respect to government technology, if it is used, it is by Center for Development of Advanced Computing. They are the ones who will provide technological support. Now what happened? They asked the question, why do we need such digitizations in election commission process? First and foremost is to remove the fake deletions or additions. Second is to strengthen electoral roll, which means if you are verifying your data, you will not do wrong data. And even if you do also, you have the option to correct it. and it prevents unauthorized manipulation. No one on your behalf can write in some paper and send it off telling you have sent it. So this is curbed. So how are they doing it? Through your CDAC and Aadhaar OTP based e-signature system. Okay, through this they are creating a digital audit. Who and all use this? When did they use this? When did they change this? What are the challenges? First and foremost, digital divide. Not everyone will be able to understand and go do e-signatures. Second thing is, in rural areas network issues are very higher. So there is large amount of rural and elderly population who do not get the idea of this. Second is privacy concerns. When you are linking your biometric information to voter ID in a very public medium, this will also create data protection issues. Last is exclusion risk. For those who have Aadhaar card, it is fine. But not everyone is having Aadhaar card or correct Aadhaar card details. For them, they have to provide some alternate verification. Okay. Next topic is Pragati. Proactive governance and timely implementation. Proactive governance and timely implementation. Done? We'll move ahead. See, your Oxford University, it will keep conducting studies and it will submit the reports. Okay. Oxford University usually in this case conducts a lot of study as to how South Asian countries are performing, how developed countries are, how developing countries are. It recently praised India's Pragati. Pragati means proactive governance, which is under Digital India initiative. In simpler sense, I'll tell you how Pragati works. Let's say central government has told Swachh Bharat Abhiyan ke liye, I have given you this much money, this much amount of toilets you have to build. State government will also do this. For how many of our states or how many of our district it has created this toilets, it will maintain one ledger. Yes, usually ledger means a documentation. This ledger was in physical form. So whenever Prime Minister wants to know what has happened, or any person for that matter, they have to physically come, ask the state, give that ledger. Okay? Or they have to tell, give that ledger to us, send it to us. They have to go check there and again find out. But now what happened, especially with your RTI and all coming in, one open digital platform, okay, where how much percentage of projects, okay, let's say in that Swachh Bharat Abhiyan they have told, in this particular districts I have did 60%, and for that all possible proof has to be provided, right? So project name and percentage of completion has to be given. Okay, this is how it is supposed to be. Now what happened? Let's assume in one particular district A, Swachh Bharat Abhiyan pe only 20% they were completing. Seeing this data is available for center, this data is available for state, this data is available even for us. Now what will happen is, earlier the center had to call all high level meetings, call the states, discuss. That was time consuming. So they started this concept of Pragati, where it is more of, let's say now online classes there, no? Same like that. The Prime Minister and let's say cabinet ministers will sit, they will conference all the state ministers. Why this project only this much percent is completed? Why have you not improved on this? Okay, it is instant, it is effective. That is your Pragati. Because of this way, your one particular mission, for example, Jal Jeevan mission, it was only somewhere around 17 or 18% only completed. But because of constant monitoring through Pragati and Prime Minister, through that, they have now come up to 70 odd percentage of completion. Understanding? So, they have accelerated, because of Pragati, they have accelerated 340 delayed projects. Understanding? This has improved more amount of money, accountability and transparency. This Pragati was launched under Digital India Initiative. This is for e-transparency and e-accountability. Directly chaired by Prime Minister through video dashboards and conferencing. Done? We'll move ahead. What are the key features of your Pragati? Key monitoring of real-time data and also direct PMO interface, that is Prime Minister Office can always monitor the projects and it will resolve any grievances or why a project is getting stuck. Understanding? And this is also giving time-bound implementation. One example of this is, for example, your Jal Jeevan mission. Okay, the connections initially were 2019 stuck at 17%. It now rose to 79%. One of the main reasons is because of your Pragati. And also your Chenab bridge and your Bogibeel bridge were also fast tracked because of Pragati. Understanding? Last topic, personality rights in India. Done? First and foremost, personality rights means anything about how a person looks, speaks, or they have a unique trait. Okay? Personality in the self itself is, okay, unique traits. That is the keyword you have to understand for this. Why we are discussing this means recently your Delhi High Court granted relief to Aishwarya Rai and Abhishek Bachchan against AI granted or AI altered data of their personality. Understanding of their personality means either someone who looks like them or something they are speaking. The video will appear like one more thing is shadow AI. Shadow AI means their face will not be visible. But all these actors will have some signature unique traits that will be visible. So it's technically like we are not showcasing the celebrity, but we all know what that celebrity is. Understanding? That is called as your shadow AI. Now this concept of personality rights means celebrities' images, voices, likeness and persona. Here the likeness is where even though if you blacken the entire image, by what that person is doing, you can know that this is this actor. Understanding? This is called personality. Now this particular personality rights, we don't have a statutory protection, which means we do not have one comprehensive law to deal with personality rights in India. So how judiciary is granting relief means based on various other cases where it has taken a standing. That has included various other actors. First and foremost, why is this there? Is to prevent false endorsement, deep fakes and exploitation. And as of now, this has become even more important in the present times is not just celebrities, even ordinary citizens, especially women, are getting more and more harassed is because of your deep fakes. Okay? Because of this, many people are threatened that even though this is fake, I am going to spread this around and make people believe, make sure that the society will see you. That is, generate a possibility of doubt whether this is real or not real. But either way, there will be a character assassination on you. Yes or no? So that will create huge pressure for that individual, whether be it a celebrity or a non-celebrity. That is what they are trying to, let's say, one of the main questions that they are discussing because of this particular case is, we need an actual statutory law to deal with this personality rights, not just of celebrities, even of ordinary citizens. Understanding? So what is personality rights? Protection of an individual's name, image, voice, likeness, signature, or even catchphrases that they use. In Constitution, how are individuals protected? Example is your Article 21, your right to life. Right to life also includes right to dignity. Right to dignity also includes right to personal liberty. So when you take those, which means you're taking away Article 21. Also, these people are protected under Copyrights Act of 1957, which means exclusive performer rights. Your people like Shah Rukh Khan, Priyanka Chopra, Ajay Devgan, all of these people have asked for, let's say, SRK. That name, they can tell this is my copyright. No one can use it without my consent. Understanding? So, section 38B has moral rights, which means the celebrities can allow their images for your commercial purposes. But that also has a limit when it infringes their personal rights. So, on moral rights, that is, I will allow my images to be used. But if it is affecting me or if it is without my consent, that point of time, I can raise a issue against you. So, this is protected under Copyright Act of 1957. So, trademarks are also allowed. Understanding? That is, they can trademark their signatures, not the physical signature, that their style of performance. So much so that this concept of trademarks act in the Western countries, if you would have seen some dishes that we will eat, right? Even dishes are trademarked or they are patented. How? The way of preparing the dish gets patented and trademarked. So this trademark can be applied to a very large aspect. Next is with regard to goodwill and misrepresentation. Now the judiciary clarified. See, first and foremost, with respect to your Article 19(1) of A. What is Article 19(1) of A? Freedom of speech and expression. Excellent. This should not be violative, which means if you tell, for example, I can't stand in a public podium and tell Aishwarya Rai, Abhishek Bachchan, if I can't even use their names, then that would mean a curbing of my Article 19(1) of A. Me creating memes on them, satires on them, okay, jokes on them, it is all coming under your freedom of speech and expression. This is permitted. Understanding? But if it goes to a level of, let's say, showing them in a very indecent manner, doing more of profane, provocative things, those things are considered harmful. So there has to be a line between freedom of speech and expression and profanity or hurting them. That is what your judiciary is trying to create. If you see, there is a history of judicial proceedings where judiciary has held that these people can protect their likeliness. One is in Rajgopal versus State of Tamil Nadu in 1994. They said a person has the right to control his identity. Understanding? No one should imitate him. Second thing is in your Rajnikant case, this is where I told you, that shadow AI. It will look like that is not the person. You can't see the person's face. It will be a shadow. But his hairstyle, his way of action, everything mimicking will look like yes, it is this actor only. So in this particular case, it was held that infringement occurs even if no deception, which means you cannot see that person physically, but you can identify which celebrity that is. Understanding? That will also come under the likeliness. Next, in Anil Kapoor case, the catchphrases whatever they tell, that is also protected against criticism or parody. That is, you can make jokes and satires on them, but you can't misuse it for promoting something that they have not agreed upon. In Jackie Shroff case also, they said you cannot use a person AI generated image for commercial venture benefit when they have not signed a deal with you. In Arjit Singh, the judiciary told that the person, it looks like him in previous cases we saw. In Arjit Singh case, it was not that person is visible, but it was his voice. AI voice cloning was used. They said even that is not permitted. All of this comes under a person's persona. Understanding? This is what your judiciary had ruled. Then recently another thing with respect to the differences in these two particular cases, DM case and DC case, that is what we will refer to it as. See, if a particular comedian, in both these cases the similarity is making fun of you, okay, in a light hearted manner, it is just humor, satire, meme, you can't raise objection telling that they cannot use my name at all. They have freedom of speech. But if in any way it is promoting a altered usage, if someone is trying to, let's say, put out a hate crime or against particular religious sentiments, and you are not that person, or that is not your belief system, then you can raise a case against them and even ask them for compensation. But just for satires, memes, you can't ask. Okay, that was your DM case and DC case. Here the question came is, and this is what right now the debate as to do we need a statutory law means, it is the fight between Article 19(1) of A, that is free expression, versus personality rights. Judiciary as of now tells that commercial misuse is not coming under free speech. Purposefully you are using a particular celebrity, let's say, who has not signed a deal with you, and telling that yes, this person is promoting my product, is you are trying to make profit off of that person without that person agreeing to it. That will not come under free speech. Okay, that is what your judiciary is trying to tell. But under Article 19(1) of A, it protects satire, parody, caricature, news, scholarship, arts, memes, all of those will come under these. If just because someone is making a meme on you, you can't go file a case on them, ask for compensation. Okay, this is with regarding to your personality rights. Issues are fragmented enforcement. Why? Because we do not have one single particular legislation to deal with this. And second is risk of censorship. Too much censoring if you do, it will curb artistic freedom, which is again nothing but your Article 19(1) of A violation. Understanding? With this we complete personality rights. This is the last topic. Clear up until here?